Hi everyone, welcome back to my channel, and today we are going to discuss about Industrial Disputes Act 1947. So today we are going to discuss about some of the important definitions and the object, aim, and the an intro towards Industrial Dispute Act 1947. Introduction. Labor legislation in any country should be based upon certain principles like social justice, social security, and national economy. Social justice implies two aspects. First, it calls for equitable distribution of profits between the owner and the employees. Secondly, it demands safety of workers and protection of their health from harmful effects of work and working conditions. Under the Workmen's Compensation Act, compensation is paid to an injured workman provided the injury was caused by an incident or accident arising out of and in the course of employment. The Minimum Wages Act, Factories Act, Payment of Wages Act, etc., upholds the concept of social justice as the living concept and give meaning and significance to the ideal of welfare state. Article 38 of Indian Constitution envisages that the state shall strive to promote the welfare of the people by securing and protecting a social order in which justice, social, economic, and political shall inform all institutions of the national life. Again, Article 39 provide that it shall be the duty of the state to apply certain principles of social justice in enacting laws. Social security is the most important principle to be followed by the legislature while enacting laws. Social security means not only individual security but also the security of the workers as a class. Industrialization brought about the Industrial Revolution, which created many labor problems besides unemployment. In modern times, social security is achieved through legislation and implementation of welfare enactment. According to V.V. Giri, social security is a security that the state furnish against the risk which an individual of small means cannot withstand. Labor problems in Indian industry. Now, social security envisages that member of a community shall be protected by collective action against social risk. These risks are such that an individual of small means cannot tide over all by himself. The underlying idea behind social security measure is that a citizen who has contributed to his country's welfare should be given protection against certain risk. Now, social security. Social security means a guarantee provided by the state against certain risk to which the members of the society are exposed. Social security legislation constitutes an important step towards the goal of welfare state. It enables the workers to be more sincere to their work. Therefore, social security measures are not only useful to the state but also help in introducing an element of stability. The report of National Commission on the Labour has observed that social security has become a way of life, and these measures have introduced an element of stability and protection in the midst of stresses and strains of modern life. Everyone has the right to a standard of living adequate for the health and well-being of himself and of his family. Thus, in our country, the social security legislation like the Workmen's Compensation Act, Factories Act, enacted etc. enacted from time to time have created some kind of industrial peace in the nation and conferred an element of happiness and security. It also facilitated introduction of uniform rules as for the working class is concerned. During post-independence era, we have witnessed the development of industrial jurisprudence. The industrial law in pre-independence period was in rudimentary form, but later on, with the development of industry, the industrial law was developed side by side. The growth of this law was slow, as only very few cases went before the Supreme Court on industrial law matters. A large section of the Indian population is affected by industrial laws. Industrialists and their workmen are directly affected, and many others are indirectly affected by these laws. The economic growth of a country depends to a great extent upon the industrial development, and as for the progress of a country is dependent upon the development of the industry. The industrial laws play an important role in the national economy of a country. The Industrial Disputes Act 1947. The object of relations legislation in general is industrial peace and economic justice. The property of any industry, the prosperity of any industry very much depends upon growing production. The production is only possible when the industry functions smoothly without interruptions. There are also some other factors that influence production, namely absence of dispute, that is, harmonious relationship between the labor and the management. Therefore, every industrial relations legislation necessarily aims at providing conditions congenial to industrial peace. Economic justice is another objective aimed at by such legislation. Almost all interruptions in production are due to the industrial disputes. Dissatisfaction among workers lead to labor struggle. The workers make continuous demand for fair return for the labor provided by them. They want return in varied forms. Their demands relate to an increase in wages, resistance to decrease in wages, and grant of allowance and benefits, etc. If a laborer wants to achieve these goals individually, he fails because of his weaker bargaining power. The management, with its better economic footing, stands in a better position to dictate terms. Therefore, the labor organizes and bargains collectively. When he does this, he is definitely placed in a better position to exert greater pressure upon the employees who invest capital to provide them fair return of their labor. It is with a view to providing economic justice by ensuring fair return to the labor that the state, as the custodian of the public interest, intervenes by state regulations. Economic justice has also been guaranteed to the people of India by our constitution. The concept of welfarism is closely connected with the industrial growth of a nation. The industrial growth can be properly achieved only by creating an appropriate machinery to solve labor problems. The industrial law in pre-independent period was in an infant stage. With the march of time, the industrial law grew and came to the forefront. The advent of the mechanical inventions has brought industrial friction and unrest throughout the world. It had therefore naturally affected the industrial growth too. The two world wars had many evil consequences in the labor field. However, after the Second World War, the industrial sky became clear. The experience of the working of the Trade Disputes Act 1929 and its defect finally paved the way for a comprehensive legislation to lessen the industrial friction and evolve effective remedies. In the words of Richard Lester, the community as a whole has an interest in industrial relations and labor disputes. Strikes and lockouts may cause inconvenience to the society. The preamble of Industrial Dispute Act declares that the object of the enactment is the proper adjustment of relations between labor class and capitalist class. The purpose of the act is to maintain industrial harmony. The Supreme Court in Surajmal Mehta's case 1969. Surajmal Mehta's case 1969. The Supreme Court held that overriding purpose of the act is the benefit of the community at large and not the benefit of the working class exclusively. In Workmen of Dimakuchi Tea Estate versus Management of Dimakuchi Tea Estate 1958. The Workmen of Dimakuchi Tea Estate versus Management of Dimakuchi Tea Estate 1958. The court observed that the main purpose of this act, that is Industrial Dispute Act, is to enable collective bargaining and to observe industrial peace by providing for recourse to the machinery and process under the enactment. In Workmen versus Hindustan Liver Limited, in Workmen versus Hindustan Liver Limited 1983, the Supreme Court held has ruled that Industrial Dispute Act was designed to provide a self-contained code to compel the parties to resort to industrial arbitration for the resolution of existing or apprehended disputes without prescribing statutory norms for varied and variegated industrial relations. The Act is applicable to an existing and not a dead industry. The Industrial Dispute Act 1947 extends to the whole of India. It came into operation on the first day of April 1947. It came into effect on operation on 1st of April 1947. The Act has made amended in 1982 and in 1984. Main objects of the Act. The main objects of the Act are 1. To secure industrial peace, that is by preventing and settling industrial disputes between the employers and workmen. Then the second, by securing and preserving amity and good relations between the employers and workmen through an internal works committee, and by promoting good relations through an external machinery of conciliation, courts of inquiry, labor courts, industrial tribunals and national tribunals. And the second objective is that to ameliorate the condition of workmen in industry, that is A, by redressal of grievance of workmen through a statutory machinery, and B, by providing job security. So the main objects of the Act is divided into two. The first one, to secure industrial peace, and the second one, to ameliorate the conditions of workmen in industry. So with respect to securing industrial peace, three scenarios are discussed. A, by preventing and settling industrial disputes between the employers and workmen. B, by securing and preserving amity and good relations between the employees and workmen through an internal works committee. And C, by promoting good relations through an external machinery of conciliation, courts of inquiry, labor courts, industrial tribunals and national tribunals. And then with respect to ameliorate the conditions of workmen in industry, two scenarios are discussed. A, by redressal of grievances of workmen through a statutory machinery, and B, by providing job security. Now, the main features of the Act. Some of the distinguishing features of the Industrial Disputes Act 1947 may be grouped as follows. 1. Strike and lockouts are prohibited under the following situations, and the situations are: A, during the pendency of conciliation and adjudication proceedings. B, during the pendency of settlements reached in the course of conciliation proceedings. And C, during the pendency of awards of industrial tribunals. Strikes can be prohibited by the appropriate government, and these are discussed in section 22 and 23. So the features main features. The first feature is strikes and lockouts are prohibited under some circumstances, and we discussed three circumstances. The first one being that there is a pendency of conciliation and adjudication proceeding. The second one, when there is a pendency of settlements reached in the course of a conciliation proceeding. And the third one, when it is prohibited by appropriate government. Now, the second main feature is that any industrial dispute may be referred to an industrial tribunal where either both the parties to such dispute agree or the state government deems it expedient to do so. Then the third main feature, an award shall be binding on both the parties to the dispute for a specified period not exceeding 1 year. It shall be normally enforced by the government. And the fourth main feature, the Act provides relief to workmen in the event of layoff or retrenchment. Now the fifth main point, the Act provides for payment of compensation to workmen in case of transfer or closure of an undertaking. Now, the sixth main feature, in public interest or emergency, the appropriate government has the power to declare the following industries to be a public utility service for the purpose of this act for a maximum of 6 months at a time. It may be extended from time to time by notification in the Gazette. Now, these industries discussed here is that the first one, A, transport other than railway for the carriage of passengers or goods by land, water or air. B, coal. C, cotton textiles. D, foodstuffs. E, iron and steel. So, for the public interest or during emergency, the appropriate government can declare either of these or all of these to be a public utility service for a maximum of 6 months at a time, and it may be extended from time to time by notification in the Gazette. Now, the seventh main feature is that it enables workmen to achieve their demands by using the weapon of strikes and thus facilitates collective bargaining. Now, the eighth main feature is that the Act enables the state to play a vital role in promoting the concept of welfare state. So, these are the 8 main features discussed for Industrial Dispute Act, and the objectives of the Industrial Disputes Act are divided into 2. So, with that, we are moving on to the important definitions under Industrial Disputes Act. So, the first definition we are going to discuss is about industry, and that is defined in section 2 subclause J of Industrial Dispute Act. Section 2 subclause J. Section 2 subclause J of the Industrial Dispute Act defines industry. According to the definition, industry means any business, trade, undertaking, manufacture or calling of employers, and includes any calling, service, employment, handicraft or industrial occupation or allocation of workmen. The definition refers to what the employers and workers do as part of their ordinary business. The definition led to the divergence of views to determine whether a firm is an industry or not. So, industry is defined under section 2J, and it is an inclusive definition which include any kind of business, trade, undertaking, manufacturing or calling of employers or allocation of employers or service, etc. Now, before the act or the old view, before 1982, industry means any business, trade, undertaking, manufacturing or calling of employees, and includes any calling, service, employment, handicraft or industrial occupation or allocation of workmen. So, the Industrial Dispute Act was amended twice, that is in 1982 and 1984. So, this before 1982, industry means any business, trade, undertaking, manufacturing or calling of employers, and includes any calling, service, employment, handicraft or industrial occupation or allocation of workmen. The definition has 2 parts. The first part says that industry means any business, trade, undertaking, manufacturing or calling of employees. And the second part provides that it includes any calling, service, employment, handicraft or industrial occupation or allocation of workmen. Simply stated, industry means something which is created or produced by the joint effort of capital and labor. It is an area where there is the joint enterprise of capital and labor. An industry exists only when there is a relationship between the employer and the employees. Now, here we have some case laws. That is, the first case law we are going to discuss about hospital. So in State of Bombay versus Hospital Mazdoor Sabha 1960. State of Bombay versus Hospital Mazdoor Sabha 1960. Here the Supreme Court held that a hospital is not an industry. Supreme Court held that the hospital is not an industry. Similarly, in Dhanarajagiri Hospital Sholapur versus Workman 1975. Dhanarajagiri Hospital Sholapur versus Workman 1975. Here, the Supreme Court held that the Dhanarajagiri Hospital was not an industry because it was not carrying on any economic activity in the nature of trade or business. This view is not applicable now because of the ruling in Bangalore Water Supply versus A. Rajappa. So, the earlier view was that hospital is not an industry. And in Dhanarajagiri Hospital Sholapur versus Workman, the Supreme Court explained why a hospital is not an industry because there is no trade or business. But later, by the ruling of Bangalore Water Supply versus A. Rajappa, this view was overruled. Bangalore Water Supply versus Rajappa is a 1979 case. Now, the next we are going to discuss about Gymkhana or club. So, in Madras Gymkhana Club's case, that is 1968. Madras Gymkhana Club's case, 1968. The Supreme Court ruled that a Gymkhana club was not an industry. Supreme Court ruled that a Gymkhana club was not an industry. This was a members club with 1,200 members. Its object was to provide a venue for sports and games, mainly intended to improve the health of the members. It was running a catering department which provides food and light refreshment only to the members. On certain occasions, guests of the members were also treated with previous notice. Supreme Court held that the club was a members' self-serving institution and not an industry. So the dismissal of a canteen boy cannot be treated as an industrial dispute. In view of Bangalore Water Supply's case, this could not be deemed to be an industry. Now, the next we are going to discuss is about a lawyer's firm. The old view, that is before 1982, is that it is not an industry. But in the light of Bangalore Water Supply case, it must be held an industry. So, the old view and the new view. The old view is before 1982. To be precise, it is before the judgment of Bangalore Water Supply case. So, the next we are going to discuss about a hair cutting salon. So, in Royal Hair Cutting Salon, Bangalore versus Workman, here the Supreme Court held that it was not an industry. But in the light of Bangalore Water Supply case, it must be deemed to be an industry. So, with respect to a lawyer's firm, the old view is that it is not an industry. But in the light of Bangalore Water Supply case, it shall be deemed to be an industry. Same way, in a hair cutting salon, Royal Hair Cutting Salon Bangalore versus Workman, the Supreme Court held that it is not an industry. But in the view of the Bangalore Water Supply case, it shall be held as an industry or deemed to be an industry. Now, the next we are going to discuss is Chartered Accountants or Auditor's Office. Tracer and Rose versus Sambashiva Iyer, 1959, Madras. So, Tracer and Rose versus Sambashiva Iyer, 1959, Madras. Here, the court held that the profession of chartered accountant and auditors cannot be said to be an industry. And then another case, that is Swarajya Ashram Kanpur versus Industrial Tribunal, 1979. Swarajya Ashram Kanpur versus Industrial Tribunal 1979. Here, Supreme Court held that Swarajya Ashram Sarvodaya Nagar Kanpur is an industry. Now, this is we discussed about the old view or the interpretation of what an industry is before 1982 or before the decision of Bangalore water supply case. Now, the modern definition. The definition of industry was statutorily modified by the Amendment Act of 1982. The amendment was necessitated as a result of the Supreme Court verdict in Bangalore water supply case. Now, Bangalore water supply versus A. Rajappa 1978. Bangalore water supply versus A. Rajappa 1978. This is a very important case with respect to Industrial Dispute Act, and this is the reason why there was an amendment in 1982. In this case, a 7-judge bench of the Supreme Court exhaustively considered the scope of industry and laid down the following test, which has practically reiterated the test laid down in Hospital Sabha case. So, in Hospital Sabha case, it was held that the hospital is not an industry based on the fact that it is not a trade or business, or it is not of such a nature of a trade of business. That was the reason which was that was the test done in Hospital Sabha case. But here we in Bangalore water supply versus A. Rajappa, here triple test was laid down, and this triple test laid down or overruled the previous test or the definition in Hospital Sabha case. So, going forward with the triple test, that is where there is 1. Systematic activity, 2. Organized by cooperation between employer and employee. The direct and substantial element is chimerical. And then the third condition is that for the production and or distribution of goods and service calculated to satisfy human wants and wishes, prima facie there is an industry in that enterprise. This is known as triple test. So, the triple test, the first criteria is a systematic activity. The second criteria is organized by cooperation between the employer and employee. And this organized by cooperation, this cooperation should be direct and substantial element is chimerical. Now, the third criteria is this cooperation is done for the production and or distribution of goods and service calculated to satisfy human wants and wishes. So, these three criteria form the triple test, and if these three criteria are satisfied, then prima facie there is an industry in that enterprise. So, this was laid down in Bangalore water supply versus A. Rajappa 1978. Bangalore water supply versus A. Rajappa 1978. Now, the following points were also emphasized in this case. So, the triple test was laid down. Along with it, some points were also emphasized towards that. The first one, industry does not include spiritual or religious service or services geared to celestial bliss. Example, making on a large scale food. It includes material, services and things. Second one, absence of profit, motive or gainful objective is irrelevant. The venture in the public, joint, private or other sector. So, with respect to a venture in public, joint, private or other sector, the absence of profit, motive or gainful objective is irrelevant. The third one, The true focus is functional and the decisive test is nature of the activity with special emphasis on the employer-employee relations. The fourth one, if the organization is a trade or business, it does not cease to be one because of the philanthropy animating the undertaking. Therefore, the consequence of the decision in this case are that professionals, clubs, educational institutions, cooperatives, research institutes, charitable projects, and other kindred ventures, if they fulfill the triple test stated above, cannot be exempted from the scope of section 2 subclause J, that is the definition of industry given under Industrial Dispute Act. The present definition excludes the following from the ambit of the industry, that is 1. Any agricultural operation, 2. Hospitals and dispensaries run purely on charitable grounds, 3. Domestic services, then 4. Government activities, 5. Any activity run by cooperative society if the number of persons employed by the society is less than 10. Then fourth one, Khadi village industries. So these are exempted from the ambit of industry. In Executive Engineer MP Housing Board versus Ramesh 2006, Executive Engineer MP Housing Board versus Ramesh 2006, Supreme Court held that Housing Board of the state is an industry. In All India Radio versus Santosh Kumar 1998, All India Radio versus Santosh Kumar 1998, Supreme Court held that All India Radio and Doordarshan are industries and their functions cannot be said to be sovereign functions. Similarly, in Municipal Corporation of Delhi versus Female Workers Muster Roll, Municipal Corporation of Delhi versus Female Workers Muster Roll 2000, the Supreme Court held that the municipal corporation undertaking construction work of laying, repairing roads, etc. is an industry. In Executive Engineer Madhya Pradesh Housing Board versus Ramesh 2006, the Supreme Court held that Housing Board is an industry according to the definition of industry under ID Act. In Kamgar Union versus State of Bihar and others 1987, Kamgar Union versus State of Bihar and others 1987, the petitioner union filed a petition complaining that the workmen in the power station engaged by a contractor must be treated as a workman to claim the benefits under this law with respect to settlement of industrial disputes. The Supreme Court held that in circumstances the dispute must be regarded as an industrial dispute and hence it could be adjudicated under Industrial Dispute Act. That is Kamgar Union versus State of Bihar 1987. So here the protection of the act was given also for the people engaged by a contractor. It was argued by the Electricity Board that the work of filling the boilers hoppers was not of a permanent nature, and the fact that it was given on a temporary contract for a limited period does not by itself be a ground for not invoking Industrial Dispute Act. So now the next definition, the most important definition after industry, what we have to discuss is what is industrial dispute. Section 2 subclause K of the Act defines an industrial dispute. It means any dispute or difference between the employers and employees, or between employers and workmen, or between workmen and workmen, connected with the employment or non-employment or terms of employment, or with the condition of labor of any person. The main objective of the Act is to make provisions for investigation and settlement of industrial disputes. Therefore, the definition of industrial dispute has special significance. Now, Section 2 subclause K defines industrial dispute and the ingredients To constitute an industrial dispute, the following ingredients must be present. 1. It must happen in an industry within the meaning of the Act, that is Industrial Dispute Act. Now the second, the dispute or difference must be between A. Employees and employers, or B. Employers and workmen, or C. Workmen and workmen. 3. The subject matter. Now the subject matter of the dispute should be connected with the A. Employment or non-employment, or B. Terms of employment, or C. Conditions of labor. The expression any person may not be a single workman but means a class of workmen. Workmen of Dimakuchi Tea Estate versus management of Dimakuchi Tea Estate 1958 ensured this. In this case, the Supreme Court interpreted any person can be that not a single workman but means a class of workmen. The key words of definition are dispute and difference. In Federation of Sawmill and General Woodworkers versus James Moore. In Federation of Sawmill and General Woodworkers versus James Moore, Chief Justice Griffith observed that the term industrial dispute connotes a real and substantial difference having some element of persistency, and it will endanger the industrial peace. Workmen of Hindustan Lever Limited versus Hindustan Lever Limited. In this case, the question was whether a demand to confirm employees in an acting capacity in a grade is an industrial dispute. It was held that a demand of the workman to confirm employees employed in an acting capacity in a grade would unquestionably be an industrial dispute without anything more. Now, whether an individual dispute can be treated as an industrial dispute. Normally, an individual dispute cannot be treated as an industrial dispute. The earlier judicial view was that an individual dispute cannot be treated as an industrial dispute. But in Central Provinces Transport Services Limited versus Raghunath 1957, Central Provinces Transport Services Limited versus Raghunath 1957, Venkatarama Iyer held that an individual dispute can be treated as an industrial dispute provided it was sponsored by the trade union. Workmen of Indian Express versus Management of Indian Express 1970. In Workmen of Indian Express versus Management of Indian Express 1970. In this case, a dispute relating to two workmen of Indian Express was sponsored by the Delhi Union of Journalists, which was an outside union, but 25% of the working journalists of the Indian Express were members of that union. There was no union of the journalists of the Indian Express. Thus, Supreme Court held that Delhi Union of Journalists was competent to raise the issue because it has a representative character. Now, another case law, that is Standard Vacuum Company's case 1954. The Standard Vacuum Company's case 1954. In this case, the Standard Vacuum Company used to give annual contract for maintenance of the plant and premises. In the first year, 67 persons were employed, and in the next year, only 40 were employed. The Supreme Court held that it was an industrial dispute that is related to non-employment. Now, another case law, that is Bombay Union of Journalists versus the Hindu 1961. Bombay Union of Journalists versus the Hindu 1961. Here the Supreme Court pointed out that the test was whether the dispute was supported by the union or by an appreciable number of workmen. Now, the next important definition we are going to discuss is related to workman. Workman means any person, including an apprentice, employed in any industry to do any skilled work or unskilled, manual, supervisory, technical or clerical work for hire or reward, whether the terms of employment be expressed or implied, and for the purpose of any proceeding under this act in relation to an industrial dispute includes any such person who has been dismissed, discharged, or retrenched in connection with or as consequence of that dispute, but does not include such person, that is one who is subject to the Army Act 1950 or the Air Force Act of 1950 or the Navy Act of 1957, or the second category, who is employed in police service or an officer or an employee of a prison, and the third one, who is employed mainly in managerial or administrative capacity, or fourth, who being employed in a supervisory capacity draws wages exceeding rupees 10,000 per annum per a month, or exercise either by nature of the duties attached to the office or by reason of the powers vested in him, functions mainly of managerial nature. So when there is when workman is defined, it also have some exclusion, that is four category of persons are excluded from the definition of workman. The first category is people who are subject to Army Act or Air Force Act or Navy Act. The second category is the persons who are employed in police service or as an officer or an employee of a prison. Now the third category is the persons who are employed mainly in managerial or administrative capacity. And the fourth category is persons who are employed in supervisory capacity but draws a salary that is more than 10,000 per month, or their job is of the nature that they mainly perform the function mainly is of a managerial nature. So these four categories of persons are excluded from the definition of workman. The definition of workman has been amended by the Industrial Disputes Amendment Act of 1982. The workman's definition provided that all persons employed in any industry to do any skilled, manual, clerical, operational, technical, or supervisory work are workmen within the meaning of Industrial Dispute Act. It includes any apprentice employed by the company. The workman may be employed for hire or reward, and the contract of employment may be express or implied. The workman includes any such person who has been dismissed, discharged, or retrenched in connection with or as a consequence of that dispute, or whose dismissal, discharge, or retrenchment has led to that dispute. Now, if the workman is employed in a supervisory capacity and draws wages exceeding 10,000 per month, or exercises either by nature of his duties attached to the office or by reason of the powers vested in him, functions mainly of managerial nature, then he will not be included in the definition of workman under the Industrial Dispute Act. Now, prior to 15/9/2010, the wage limit for excluding a person from workman category was 1,600 rupees. Once again, prior to 15/9/2010, the wage limit for excluding a person from workman category was 1,600 rupees. The persons excluded are those employed in a managerial or administrative capacity. The question whether a particular workman is a supervisor within or without the definition of workman is a question of fact and law. So who comes under the supervisory role is a question of fact and law. The essential condition for a person to be a workman within the terms of the definition is that he should be employed to do the work in that industry, and that there should be an employment of his by the employer and him as between the employer and employee or master and servant. So what are the ingredients? He should be employed to do a work in that industry, and there should be an employee employer relationship, and the employment and the employment, and there should be an employment of his by the employer and him as between the employer or master and servant. So that is the main, that he should have a work in that industry and the employer should have appointed him, and there should be a master servant relationship. So these are the three criteria, that is to determine if a person is a workman within the terms defined in this act. Now, unless a person is thus employed, there can be no question of his being workman within the definition of the term as in Industrial Dispute Act. So, for a person to be a workman, what are the essential conditions? That the workman shall not be of any one of the excluded categories, that is the fourth categories, and further the person should have an work in that industry and the employer should have appointed him. The employer and this workman should have this person should be having a employer employee or master servant relationship. Now, in Devinder Singh versus Municipal Council, Sanatur, 2011. Devinder Singh versus Municipal Council, Sanatur, 2011. Here, Supreme Court held that once the test of hire or reward for doing the specified type of work is satisfied, the employee would fall within the definition of workman, and the definition does not make any distinction between full-time and part-time employees. Once again, it does not make any distinction between full-time and part-time employees, and this was held in Devinder Singh versus Municipal Council, Sanatur, 2011. In Air India Cabin Crew Association versus Union of India, 2012. Air India Cabin Crew Association versus Union of India, 2012. Here, Supreme Court held that once an employee is placed in the executive cadre, he ceases to be a workman and also ceases to be governed by the settlement arrived at between the management and workman. So that was held in Air India Cabin Crew Association versus Union of India, 2012. Further, once again, the same case we discussed earlier, the Devinder Singh versus Municipal Council, Sanatur. Here, Supreme Court held that only a person employed on a regular basis or a person employed for doing whole-time job is a workman, and that one employed on temporary, part-time or contract basis or on fixed wages are casual employees or for doing duty for fixed hours is not a workman. So, in another case, that is Venkataraman versus Labour Court, 1982. Here, the Kerala High Court held that the teacher in a school was not a workman. In S.K. Verma versus Mahesh Chandra, 1984. The development officer of the Life Insurance Corporation was held to be a workman. Keeping in view the nature of his duties performed by such officers and the powers vested in them, they cannot be said to be engaged in any administrative or managerial work. So that was held in S.K. Verma versus Mahesh Chandra, 1984. Where the employee was working under a company as an internal auditor on a monthly salary and his duties were mainly reporting and checking up on behalf of the management, but he had no independent right or authority to take decision and his decision did not bind the company, the employer would be a workman within the meaning of section 2 subclause S and not supervisor. So this is important. The definition of workman under section 2 subclause S. Where the employee was working under a company as an internal auditor on a monthly salary and his duties were mainly reporting and checking up on behalf of the management. He had no independent right or authority to take decision and his decision did not bind the company. In such a case, that auditor is brought under the definition of section 2 subclause S as a workman. An employee supervising work of maintenance department in the capacity of maintenance engineer having power to grant leave, initiate disciplinary proceeding and make temporary appointments is not a workman. That was held in Vimal Kumar Jain versus Labour Court, Kanpur. in Vimal Kumar Jain versus Labour Court Kanpur 1988, it was held that an employee supervising work of maintenance department in the capacity of a maintenance engineer having power to grant leave, initiate disciplinary proceeding and make temporary appointments is not a workman. Now, in another case law, that is Bihar State Road Transport Corporation versus State of Bihar. Bihar State Road Transport Corporation versus State of Bihar. In this case, a person was appointed as head clerk in the office of the divisional manager. There was no evidence that he was doing managerial or supervisory work. His conditions of service were governed by standing orders of Rajya Transport. He was held to be a workman. Now, BSOS and H Company Management versus Staff Association. BSOS and H Company Management versus Staff Association. Here it was held that a person cannot be assumed to be a workman on the ground that he does not come within the 4 exceptions in section 2 subclause S. In practice, quite a large number of employees are employed in industries to do work for more than one of the kinds mentioned in the definition. In such cases, a workman must be held to be employed to do that work which is in the main work he is required to do, even though he may be incidentally doing other types of work. So that was held in BSOS and H Company Management versus Staff Association. So a person might have to do multiple tasks, so the main nature of his work should be considered to decide whether he is a workman or he is doing a supervisory or managerial work. That is BSOS and H Company Management versus Staff Association. Now, in Titagur Paper Mills Company Limited versus First Industrial Tribunal. Titagur Paper Mills Company Limited versus Industrial Tribunal. In this case, a person with technical expertise was held to be a workman. Although such experts did not run the machines themselves but stood by and guarded ordinary workmen in the manner of running the machines, their job cannot be said to be purely supervisory or administrative. So they are also brought under the definition of workman under section 2 subclause S. So the next we'll be discussing of Badli workman. It is not explicitly defined. So Badli workman means workman who is employed in an industrial establishment in the place of another workman whose name is borne on the muster roll of the establishment but ceases to be regarded as Badli workman if he has completed 1 year of continuous service in the establishment. So he may be a casual or a substitute worker, but if such a person has completed at least 1 year of continuous service, then he ceases to be a Badli workman. Now the next is Labour Court. Labour Court means a labour court constituted under section 7 of the Industrial Dispute Act 1947. You can also refer to section 2 subclause KKB. Now, layoff. Under section 2 subclause KKK, layoff means the failure, refusal or inability of an employer on account of shortage of coal, power or raw materials, or the accumulation of stocks, or the breakdown of machinery, or for any other reason to give employment to a workman whose name is borne on the muster roll of his industrial establishment and who has not been retrenched. Every workman whose name is borne on the muster roll of the industrial establishment and who presents himself for work at the time appointed for the purpose during normal working hours on any day is not given employment by the employer within 2 hours of his so presenting himself is treated to be have been laid off for that day. If the workman, instead of being given employment at the commencement of any shift or for any day, is asked to present himself for the purpose during the second half of the shift for the day and is given employment, then he is treated to have been laid off only for one half of that day. If he is not given such employment even after so presenting himself, he is treated to have been laid off for the second half of the shift for the day and is entitled to full basic wages and DNS allowance for that part of the day. So, a layoff can be for a full day or a half day. So, if the employer is planning to provide employment for the second half of the shift and he's not being able to provide that employment or work during the second half also, then a half day layoff will become a full day layoff. So, the words any other reason with the explanation of layoff in the definition of layoff do not include closure of the whole business. So, with respect to layoff, we discuss shortage of power or resources or other reasons. So, these other reasons does not include the closure of the business, whole business. So, in Nutan Mills Limited, Ahmedabad versus Employees State Insurance Corporation, 1956. Nutan Mills Limited, Ahmedabad versus Employees State Insurance Corporation, 1956. Here, the question for consideration was whether, on the employees being laid off, the relation of master and servant continues and the mutual rights and obligations which flow from such relationship also continue. The relation, here the High Court of Bombay was of opinion that the relationship of the master and servant did not continue but suspend during the period of layoff, and as the contract of employment is suspended, then there is no obligation upon the employee to serve the employer, nor is there a reciprocal obligation upon the employer to pay wages. So that was held in Nutan Mills Limited, Ahmedabad versus Employees State Insurance Corporation, 1956. And then we have lockout. Lockout means the closing of a place of employment or the suspension of work or the refusal by an employer to continue to employ any number of persons employed by him. Strike is a weapon in the hands of the labor to force the management to accept their demands. Similarly, lockout is a weapon in the hands of the management to coerce the labor to come down in their demand relating to the conditions of employment. Lockout is the keeping of labor away from the work by an employer with a view to restrict their claim. There are 4 ingredients in lockout. The first one, temporary closing of a place of employment by the employer, or suspension of work by the employer, or refusal by an employer to continue to employ any number of persons employed by him. Then, the above mentioned acts of the employer should be motivated by coercion, then an industry as defined in the act, and the fourth one is a dispute in such industry. So there is mainly 4 ingredients. The 4 ingredients, the first one is temporary closing. First one is a closing that can be a temporary closing or a suspension of work or refusal by an employer. These all come under the first. That what is the incident there? What kind of denial of employment or closing of industry happens? Then the second one, there should be coercion. Such an act should be motivated by coercion. And the third one is that an industry, it should be done in an industry as per the definition of industry in Industrial Disputes Act. And the fourth one is that a dispute in such industry. So these are the 4 ingredients. There should be an act, and that act should be by coercion, and it should take place in an industry, and it should be with respect to an dispute or difference. So industry is defined in Industrial Dispute Act. What an industrial dispute is defined in Industrial Dispute Act, and we have 3 kind of factors discussed, that is temporary closing down or suspension of work or refusal by an employer to continue to employ any number of persons. So these three acts are also discussed. Now, in Kayarbeta Estate Kotagiri versus Rajamanikam, 1963. Kayarbeta Estate Kotagiri versus Rajamanikam, 1963. In this case, lockout has been described by the Supreme Court as the antithesis of strike. In Sri Ramachandra Spinning Mills versus State of Madras, 1956. Sri Ramachandra Spinning Mills versus State of Madras, 1956. In this case, Madras High Court had held the view that whatever be the circumstance in which the employer may find himself placed, and whatever may be the strength of the agencies which forced on him the step, and however important he may be to avoid the result, if the employer closes the place of employment or suspended work on his premises, a lockout would come into existence. So that was held in Sri Ramachandra Spinning Mills versus State of Madras. Now, difference between lockout and layoff. So, lockout is an act on the part of the employer taken to coerce or to pressure the labor. Layoff is for trade reasons beyond the control of the employer. That is not an intentional act. Now, lockout is due to the industrial disputes and continues during the period of dispute, whereas layoff is not concerned with the dispute with the workman. Now, difference between lockout and retrenchment. Lockout is temporary and retrenchment is permanent. In lockout, the relationship of employer and employee is only suspended. It does not come to an end. In retrenchment, such a relationship is severed and at the instance of the employer. Now, lockout is within a motive to coerce the workman. The intention of the retrenchment is to dispense with surplus labor. Lockout is due to and during an industrial dispute, whereas in case of retrenchment, there is no such dispute. Now, difference between lockout and closure. Lockout is temporary, closure is permanent. Lockout is a weapon of coercion in the hands of the employer. Closure is generally for trade reasons. Lockout is during an industrial dispute, while in the case of closure, there need not be any dispute. So that is with layoff and lockout. Now, the next is public utility service. That is defined in Section 2, Subclause N of Industrial Dispute Act. Public utility service. Public utility service means 1. Any railway service or any transport service for the carriage of passengers or goods by air. 2. Any service in or in connection with the working of any major port or dock. 3. That is the third one. Any section of an industrial establishment on the working of which the safety of the establishment or the workmen employed therein depends. Then the fourth one, any postal, telegraph or telephone service. The fifth one, any system of public service or public conservancy or sanitation. Now, sixth one, any industry which supplies power, light or water to the public. And the seventh one, any industry specified in the first schedule. The appropriate government may, if satisfied that public emergency or public interest so requires, by notification in the official gazette, may declare any industry specified in the first schedule to be a public utility service for the purpose of the act for such period as may be specified in the notification. So we already discussed what are the kind of industries that come under this section and which can be defined as a public utility service. We discussed it under while we discussed about the definition of industry. And we also discussed that it is generally for a period of 6 months and it may be extended from time to time by official notification in the Gazette. Now, Saxby and Farmer, India versus Workman, 1975. Saxby and Farmer, India versus Workman, 1975. The appellant company was a unit of engineering industry engaged in production of equipment for the railways. It was declared a public utility service. The management curtailed unpaid festival holidays as a system of unpaid holidays was no longer followed in any major industry of the region. It was held that there should be more concentration on increase of production and efficiency than enjoying the holidays if the country is to march ahead on the road to prosperity. As such, there was no reason or justification for the unpaid holidays not being curtailed, provided that the period so specified shall not, in the first instance, exceed 6 months, but may, by a like notification, be extended from time to time by any period not exceeding 6 months at one time, if, in the opinion of the appropriate government, public emergency or public interest requires such extension. The industries enumerated in the first schedule are transport, that is, other than railways, for carriage of passengers or goods by land or water, banking, cement, coal, cotton textiles, foodstuff, iron and steel, defense establishments, service in hospital and dispensaries, fire brigade service, Indian government mints, India security press, copper mining, lead mining, zinc mining, iron ore mining, and service in oil field. So these are the industries that is discussed under the first schedule, which may be categorized as a public utility service if the appropriate government decides so in the for the public interest or public emergency. So the next one is retrenchment, that is section 2 subclause OO, that is double O, section 2 subclause OO. Retrenchment means the termination by the employer of the service of a workman for any reason whatsoever, otherwise than as a punishment inflicted by a way of disciplinary action, but does not include A. Voluntary retirement of the workman, or B. Retirement of the workman reaching the age of superannuation if the contract of employment between the employer and the workman concerned contains stipulation in this behalf, or C. Termination of the service of a workman on the ground of continued ill health. According to various decisions of the Supreme Court, every termination of service is retrenchment if it is not covered by the exception under section 2 subclause OO. Retrenchment connotes in its ordinary acceptation that the business itself is being continued, but that a portion of the staff of a labor force is discharged because of surplus, because the labor is surplus. Thus, the following amount to retrenchment. That is the first one: termination for loss of confidence. Second, termination due to failure to pass the prescribed test provided for confirmation in service. Third one, termination due to reduction in the volume of business of the company. The fourth one, termination for unauthorized absence from duty. And the fifth one, termination in accordance with the standing orders due to continued absence without leave. The termination of the service of workman, though not falling under the clause A, B, or C of section 2 subclause OO, not being a punishment inflicted by disciplinary action, is still not retrenchment unless the termination of service was on account of surplus labor or staff. Thus, termination in accordance with the rules of service or conditions of appointment letter is not retrenchment. The trade union means the next one is trade union. Trade union means a trade union registered under the Trade Unions Act of 1926, and that is defined under section 2 subclause R. So the next topic we are going to discuss, or definition we are going to discuss, is trade union. A trade union means a trade union registered under the Trade Unions Act of 1926 and is defined in Industrial Dispute Act under Section 2, Subclause R. So, DC and G Mills versus Shambhunath, 1978. DC and G Mills versus Shambhunath, 1978. The respondent was a motion setter at the relevant time. There was one reorganization in the establishment and the post was abolished. Therefore, thereafter, the respondent would have been retrenched, but in terms of settlement between the management and the workmen, no employees was to be retrenched. The management agreed to offer work on any other suitable post. The respondent was found unfit for the job offered even after the extension of the probation period. Thereafter, he was offered another job on the same wages, which he did not accept. Instead, he requested the management to give him one more chance to show his efficiency. His name was struck off as the management did not accept his request. It was held that striking off name of the respondent amounted to retrenchment. Then, Morinda Corporation Mills Limited versus Ram Kishan and others. Morinda Corporation Sugar Mills Limited versus Ram Kishan and others. In this case, workmen were employed in a sugar mill during crushing season only. Consequent to closure of season, they ceased to work. It was held that such cessation of work would not amount to retrenchment since it is only a seasonal work. So that was decided and clearly explained in Morinda Corporation Sugar Mills Limited versus Ramkishan and others that the retrenchment, the cessation of work in case of seasonal work is not a retrenchment. Now that is with retrenchment, and the next we are going to discuss about tribunal. Tribunal means an industrial tribunal constituted under section 7 capital A 7A of this act. It includes an industrial tribunal constituted before 10th March 1957. So it also includes an industrial tribunal constituted before 10th March of 1957 under the act. In Agra Electric Supply Company Limited versus Workman, Agra Electric Supply Company Limited versus Workman 1987, there was an industrial dispute between the parties relating to a claim for retrial benefit of 32 workmen relating to gratuity. The award was passed by the tribunal on April 18, 1973, and the Supreme Court affirmed the decision. Now, appropriate government, that is defined in Section 2 Subclause A. Section 2 Subclause A. Appropriate government. Section 2 Subclause A of the Industrial Dispute Act defines appropriate government. Appropriate government is the proper government to refer any industrial dispute to the proper authority. Under Section 10, the opinion of the appropriate government is necessary. Central government is appropriate government for certain categories of industry. For certain other categories of the industry, the state government is the appropriate government. In the following cases, central government is the appropriate authority of government, appropriate government. The first one, any industry carried on by or under the authority of the central government. Second, any such industry as may be specified in the behalf of the central government. Third, any industry carried on by a railway company. Fourth, Dock Labour Board. Fifth, Industrial Finance Corporation. Sixth, the Employees State Insurance Corporation. Seventh, the Board of Trustees. Eighth, the Indian Airlines and Air India. Ninth, the Life Insurance Corporation of India. 10th, the Oil and Natural Gas Commission. 11th, the Deposit Insurance and Credit Guarantee Corporation. 12th, the Center Warehousing Corporation. 13th, the Agricultural Refinance and Development Corporation. 14th, the Unit Trust of India. 15th, the Food Corporation of India. 16th, the International Airport Authority of India. 17th, Regional Rural Bank RRB. 18, the Export Credit and Guarantee Corporation Limited. 19, the Industrial Reconstruction Corporation of India Limited. 20, Banking Company. 21, Insurance Company. 22, Mines. 23, Oil Fields. 24 Cantonment Board, 25 Major Ports, 26 Board of Trustees of Coal Mines Provident Fund Act 1948 and E&F Miscellaneous Provisions Act 1952, 27 National Housing Bank, 28 Air Transport Service. So for all these industries, the appropriate government is the central government. Now, in all other cases, the appropriate government is the state government. The power to refer an industrial dispute is vested with the appropriate government. The question whether the appropriate government is a central or state government depends upon the subject matter of the dispute. Now, in Goa Sampling Employees Association versus General Superintendents Company of India. In Goa Sampling Employees Association versus General Superintendents Company of India 1985. Here the Supreme Court held that central government is the appropriate government in relation to an industrial dispute that arose in union territory. So if the industrial dispute is in a union territory, the central government is the appropriate government. The test to determine the appropriate government is to be based upon the following facts. First, whether the industry is run by the authority of the central government, and secondly, whether the management of that industry is done by an agent of the central government. So this was laid down in Goa Sampling Employees Association versus General Superintendents Company of India 1985. In Sri Shankara Alam Limited versus State of Travancore and Cochin 1953. Sri Shankara Alam Limited versus State of Travancore and Cochin 1953. The business of manufacturing of salt carried on by private company under a license from the government would not merely by reason of the license become a government business carried on by or under the authority of government. So if the business carried on after getting a license from the government, that does not mean that that industry is run by the government. So that was held in Sri Shankara Alam Limited versus State of Travancore and Cochin. Here it was regarding the manufacturing of salt with the license from the government. Bharat Glass Works Private Limited versus State of West Bengal. That is 1957. Bharat Glass Works Private Limited versus State of West Bengal 1957. The company carried an industry of manufacturing glass and ceramics. The management argued that it was a controlled industry and therefore central government is the appropriate government to refer the dispute. The court ruled it was a controlled industry and as such the reference made by the state of the West Bengal was bad. So that was the case was Bharat Glass Works Private Limited versus State of West Bengal. So here the test was that the industry is a controlled industry and the industry was glass and ceramics. Now, Indian Naval Canteen Control Board versus Industrial Tribunal 1965. Indian Naval Canteen Control Board versus Industrial Tribunal 1965. Here, the Kerala High Court held that the question of appropriate government is essentially a question of fact depending upon the circumstances of each case. It was held that in regard to the business carried on by a naval canteen, central government is the appropriate government. Now, Association of Medical Representative versus Industrial Tribunal. Association of Medical Representative versus Industrial Tribunal 1965. A company having its head office at Bombay engaged medical representatives to work in the area of the state of Madhya Pradesh where it had no establishment. The work of the medical representative so appointed was controlled and supervised by the health officer at Bombay. A medical representative working at Madhya Pradesh was discharged. The question was whether Bombay or Madhya Pradesh government was the appropriate government to refer the matter. It was held that though the concerned salesman was residing in Madhya Pradesh, the dispute arose in Bombay. It was further observed that the government of the places where the order is served cannot be denied the power to make reference. Then we have workmen of Sri Nagavilas Motor Private Limited versus Management of Sri Nagavilas Motor Private Limited. Workman of Sri Nagavilas Motor Private Limited versus Management of Sri Nagavilas Motor Private Limited, 1967. A workman was transferred from Bangalore, that is the Mysore state, to Krishnagiri in Madras, or to the Madras office by Employer Motor Company. So, in Workman of Sri Nagavilas Motor Private Limited versus Management of Sri Nagavilas Motor Company, the workman who was working in Bangalore, that is in Mysore state, was transferred to the Madras office at Krishnagiri Madras office, office of the Employer Motor Company. The dispute was sponsored at Krishnagiri. So, the Supreme Court held that the Mysore state was competent because of his substantial connection. Here, though the person was already transferred to the Madras office, the substantial connection of the dispute was at Mysore, so the Mysore state had the competency to refer the case. That was held in Workman of Sri Nagavilas Motors Private Limited versus Management of Sri Nagavilas Motor Private Limited, 1967. So that is with the end of this session. We covered the objective aim of Industrial Dispute Act and the important definitions under Industrial Dispute Act and some of the relevant case laws with respect to it. The important definitions are mostly industry, what an industry is, what is industrial dispute. Then we discussed about layoff, lockout, retrenchment, appropriate government. So, or we discussed the important tribunals, important definitions, and the relevant case laws. Thank you for listening. Like, comment, and subscribe. Don't forget to click the bell icon so that you get an update when I upload my next podcast or a video. Thank you all for your support. Have a nice day. Take care.